Right on to this now. According to reports quoting the Department of Home Affairs, the latest in the ZEP matter is that two organizations have withdrawn their legal challenge against a Home Affairs directive not to renew the Zimbabwe Exemption Permits. It affects 200,000 Zimbabweans living in the country. The department welcomed the withdrawal by the African NPC and Zimbabwean Permit Holders Association. But it remains locked in an acrimonious legal stare-down with the Helen Suzman Foundation, which has filed an application against the permit's withdrawal. For more, we're joined now by the African Diaspora Global Network CEO, Dr. Vusumuzi Sibanda, immigration expert Gary Eisenberg, human rights lawyer Lindokuhle Mdabe and Forum for Service Delivery Head of Presidency and International Relations, Tonic Manchidi. And by the way, as we get into this conversation, an invitation was extended to the Department of Home Affairs. By the time we came on air, we've still not received a reply from them on whether or not they will be participating in this conversation tonight. But we did put out a question on Twitter, and that question is, should the Home Affairs be criticized for the withdrawal of the Zimbabwe special permits? These are some of your thoughts tonight on this. Patricia Kumala saying, South Africa is a country with laws on immigration. Why must the minister be criticized when he implements and enforces the law? Nick saying, why is that even a question? They are enforcing the law, of which you all should be encouraging. Media and NGOs keep pushing this narrative of South Africans being xenophobic. South Africans are protecting their country and interest. Illegal immigrants and criminals coming outside of South Africa cannot be allowed to destroy the country. We have our own criminals to deal with, so to speak. Why should Home Affairs be criticized for implementing the country's laws? Those are just some of the thoughts that, of course, are being put out there on social media. We'll bring you the results of that poll a little bit later on. Once again, to remind you, we did reach out to Home Affairs to be a part of this conversation tonight. We have not yet received a response from them at the time of going to air. But let's welcome our guests. Good evening, everyone, and thank you very much for your time and for joining us tonight. Dr. Sibanda, let me start with you here in the studio. Is South Africa being prevented from implementing its immigration laws? The Home Affairs Minister, I quote, in an earlier interview with one of my colleagues, says South Africa is trying to control and regularize their immigration laws, so they don't really understand why they are being prevented from doing so.
Good evening and thank you. I don't think that South Africa is being prevented, and I think the criticism is not for, why the minister is withdrawing, the permits. The criticism is about the manner in which it is done. If a government department, for example, like what we're saying, about the minister, is that he has got to take such a decision, it is the Immigration Act. We're not even talking about, the Constitution. That requires him that when he makes a decision that adversely affects the rights of any person, that person must be invited to make, representations. And the Department of Home Affairs only did that after the first, urgent court applications that were made on the 14th of December and the 31st of December 2021. And their first invitation was dated the 6th of January, if not, the 6th of January, to say, a decision has been made, can you make representations? And an email was given, which is actually, it doesn't help anyone because the decision is made already. You're actually telling the people that now they should now start applying for other permits, which they ordinarily would not qualify for. So this is not a criticism, of the minister for making the decision, but it is a criticism to say, did you follow the law? In terms of the Constitution, Section 33 is very clear, when it comes to, reviewing, such decisions. So the minister is unfortunately, I think, taking it personal, but it's not about that. It's just challenging the manner in which it's done. And if he is correct, he's done what is right, then let the court process take place because the court is a neutral arbiter to then say you have followed procedure.
So, that, of course, has been brought up by the Helen Suzman Foundation as well. And the minister says, one, we've issued directives to 178,000 permit holders via email because we've got their addresses that way. But two, we've engaged with some NGOs, okay? He admits not all NGOs. We've also engaged even with the Zimbabwean embassy on this particular matter. So as far as he's concerned, they are right on there as far as the PAJA is concerned. And that is, by the way, the public administrative action that that is required in as far as making such kind of decisions?
Well, that is not true. Completely, that's not really true. It's very unfortunate because that is not true, and it's very sad that I've got to say that. Maybe I also need to correct this fact that the department is claiming that two, organizations have withdrawn their legal, challenge, and that is not true. I was actually speaking to the advocate who's handling that and the chairperson of ZEPA. They have told me categorically they have not withdrawn anything. And it's unfortunate, again, that on the 31st of December, when we had the urgent court application, the minister went out to say the court cases that were in court were thrown out for lack of agents. That was true, because the court cases were only thrown out or withdrawn or, struck off the roll because of technicalities. And one was specifically because of an affidavit in support of the fact that there was not a duplicate case on it. Now, so when you're looking at, the consultation organizations, a lot of NGOs, in excess of 40, wrote a letter through the Lawyers for Human Rights to write to the minister well before, after the decision was made on the 24th, say, well, let's go back to the drawing table. You have not done enough in consulting. We've been writing letters to you. African Amity ZEPA, they wrote to the minister in about March and April of 2021. And a lot of other organs requesting the minister to say, a decision has not been made. There is quietness. What is going on? The minister never responded. Now he goes out, the minister, to mislead. This is unfortunate. I have to use that word. With all due respect, the minister is misleading the public when he says he consulted with NGOs before this was done. There was never any consultation. In fact, there is a barrage of letters that were sent to the minister to say what is going on. And the responses that were there were that, sit down, keep quiet, and wait. We're going to come back to you. Right. And any attempt was only done after the fact.
We did reach out to the DG at Home Affairs, by the way. I want to repeat that so that you can be a part of this conversation and respond to such things as you're putting out. We have not received a response from them, but I'm sure after listening to this conversation, they might want to answer. Lindo, let me bring you in here. In terms of procedurally fairness in administrative action affecting any persons, is the department in the right here?
Yes, there's no doubt about it. There's no intention really from the department or from the political head, who's the minister in this case, to even attempt to engage people who are affected by his decision. There's a deficit on that score. One is not questioning whether the decision by the minister is right or wrong, but what we're merely saying, and we've been saying this for quite some time, that there hasn't been sufficient time afforded to those who, of course, are affected by the decision to submit their case, to make to the minister as to why this decision is going to affect them negatively. And I think amongst the pillars of the application that has been brought by Helen Suzman Foundation, that either is the important part to the challenge. The statement by the minister was unfortunate. In fact, we're of the view that the statement is dangerous and ought not to have been made.
The minister, again, a core of what he's arguing here is that the conditions of this temporary measure have always been known. And I'm sure you yourself have looked at the conditions of all the permits in the various iterations. They clearly state that this does not entitle the holder to a right to apply for permanent residence. They say this does not entitle the holder to have this renewed or extendable. These are the conditions that have always been there. Why is this a surprise today that the permit will come to an expiration at a particular point?
Well, qualitatively, I'll not particularly that you have mentioned, because there's a bit of a mismatch with what you're talking about. Look, this is the situation, this is the crisis we are in. It is that the decision was taken for a number of reasons. One reason was that the department wanted to alleviate the backlog that was taking place in the asylum seeker refugee system. That backlog still exists. And then number two, the decision was taken because the socio-economic and political conditions in Zimbabwe were bad at the time. We are of the view that that too has not changed. The situation in Zimbabwe is still the same. The decision was also taken because the South African government was of the view that the critical skills and employment that was the Zimbabwean migrant was going to benefit the country. All of those things are still there. They're still intact. Nothing has changed qualitatively. Now, one wonders why the decision has been taken and why it is taken in the manner in which the decision has been taken. Of course, my guess is as good as yours, but I don't want to venture into that. What I'm trying to put forward is that qualitatively nothing has changed. The decision that has been taken by the minister, right, cannot be justified against against the reasons that the department put forward before the decision was taken or was extended for a number of years.
Gary, a quick one before we go to break. Did adequate notice of the nature and the purpose of the proposed administrative action was that given in this particular matter, and the reasons behind this administrative action given equally so? Gary?
With regard to adequate notice, no, not at all. The previous speaker suggested that the conditions which led to the implementation of the ZEP program in the first place 13 years ago, those conditions have not changed. And even though each period of a ZEP for 2 or 3 years at a time, quite right, each one came to an end on its own terms, the conditions underpinning each of these ZEPs for those fixed periods of time over the last 13 years have not changed. So the internal process of reconciling these reasons and these conditions, socio-political reasons in Zimbabwe itself, which led to the influx of so many people over the years, that internal procedure, in my mind, should have given rise to some legitimate expectation, which adversely affected 178,000 ZEP holders, and therefore, in terms of Section 4 of PAJA, a notice and public comment procedure should have been held, or at least a public inquiry. We're dealing with almost 200,000 people, a human rights crisis in this country, and it's not enough for the minister simply to disseminate a number of press releases and to call it quits. That just doesn't cut it. And I think the Helen Suzman Foundation pins its hopes on this very issue in the Pretoria High Court, and we'll see how the court reacts to that in time.
We'll come back with Tonic when we return. And, of course, the conversation continues. Let's say your views at Newzroom 405. And the question, should government be criticized for the decision they have taken to not extend the ZEP permits? We continue in our statements. We're back with you tonight here on In Focus Newzroom Afrika, channel 405, and the conversation continues. Should government be criticized for its decision not to extend the ZEP for Zimbabweans? Let's look at what you're saying tonight on WhatsApp. Some of your reaction coming through. Look, Mafuro Ziviti SJ saying Department of Home Affairs should give permanent residence to ZEP permit holders because they've lived in South Africa for over 12 years. Otherwise, if they don't regularize them, there will be more illegal immigrants in South Africa unaccounted for, using taxpayers' money for services. Anonymous saying thumbs up for Our favorable minister, the only one who cares about his country, our next president of the country. Another anonymous, good evening, Thabo. Government must not renew Zimbabwean permits. We are overcrowded in South Africa. Crime is too high. All right, some of the thoughts coming through then tonight on that question. We still have Dr. Vusumuzi Sibanda, CEO of the Africa Diaspora Global Network, Gary Eisenberg, immigration expert, Lindokuhle Mdabe, lawyer at Lawyers for Human Rights, and Tonic Manchidi, Forum for Service Delivery, head of the presidency. Tonic, let's bring you in here. Are we asking the state to be malleable in its approach to governance instead of being adherent to the rule of law and upholding that? I mean, what are we asking the states to do here?
Greetings, Muruti. I'm sorry I'm in the dark here because of the red shading. I hope I'm visible to your viewers. Listen, it has been, we as Forum for Service Delivery, we are in support of what is the decision taken by the government. And then we are saying 13 years, it has been too long. Also, the state has been reasonable in a way that from last year, December, and they are given the full 1 year to apply for other visas, or otherwise they're going to be deported. And there is nothing special about deporting Zimbabweans. And also, the second thing is that South Africa is not the first state to take this kind of action. It has been happening even in the continent of Africa. It happened in Nigeria. It happened also in Gabon. So it's not the first time that is going to be this kind of action is going to be taken. We are sitting, South Africans are sitting in the dark now because our electricity is overloaded. So I think what I believe also, and we hope that Aaron Motsoaledi is not just campaigning for votes, preparing for 2024. This is not just electioneering. By the minute, come December, those who are not documented in our country must leave the country.
Okay. Tony, it muddies the water, I suppose, when we begin to enter into that conversation. I was trying not to go into that conversation because I really just want to talk about the legality of this particular process. But nonetheless, you will respond if you do want to respond to it. The question is, and part of what Tony is saying is also part of what I'm trying to say here, is that Angolans have been issued with a similar directive. That's according to the minister. And other nationals have been issued with a similar directive. And there was no public inquiry process that was called for. Why must it happen for Zimbabweans? Dr. Sibanda?
Again, there is an Angolan dispensation permit, and there is a Lesotho dispensation, which is still in existence. So I'm not sure what the minister is talking about when he says a similar directive has been issued, particularly to say, any other directive to say people should then leave or they're not going to be, it's not going to be extended, is coming in. Because, the Lesotho exemption permit, which came in because Angola has been quite in, for quite a long time. There's no directive like that that's been issued. So it's unfortunate, when the minister comes and says a similar, and also, when we say that other countries have done this. I think as a country that is, has got, a constitution and the law embedded in democracy and open democracy and human rights, we cannot be saying if another country has done something that is unlawful, that violates, human rights and brings up a humanitarian crisis and human rights, but we should do it because it has been done elsewhere. Because the idea, I think you've rightfully said it, that the issue is let us uphold the law. What does the South African law say? We've got PAJA, we've got Section 33, which is, 33 of the Constitution. We've got, rights that are, that are accrued to any other person. And we've got, like what Gary said, the legal expectation that arises from a particular action, despite the fact that where could this action have come from, even from from a good place. But when people live in a country or anywhere else, they accrue certain rights over time. So when you make a decision going forward, you need to make sure that you cannot trample down, on those people simply because you said, I assisted you or I was sympathetic when I did this. You could have been sympathetic, but now if rights have accrued, then you need to follow the proper procedure in order to ensure that you don't violate those rights.
The rights are not automatic, and this is what Home Affairs is arguing. That in any country, it doesn't mean that just because you have stayed, those rights are automatic. You still need to go through a process of regularizing. Now, you've got this call to regularize 2,300 visa applications, 3,000 waiver applications, as compared to the extent of people with permits. I mean, that says, explain to me why there is no desire to at least apply and regularize.
Look, I think it's unfortunate that we get confused, by semantics. I don't want to go there because when we talk about regularizing, we're talking ordinarily about people that do not have any form of documentation. Those are people that are irregular. We don't use the word, illegal immigrants. We use the word irregular and regular for people that are documented. So the 178,000 are regularized already. And they are not only regularized in terms of a Bush law, but in terms of the Immigration Act. I hear every now and again people saying, no, we are applying the Immigration Act. The Immigration Act, this particular permit that Zimbabweans have, it is a child, of the Immigration Act. So these people are regularized. But now to say, moving forward to say, you want them to apply the mainstream, and people are saying, yes, you are saying that, but did you do due diligence and follow procedure? Because law must be substantively, and procedurally fair. And this is what the outcry is all about. It is not about scraping it out. It is all about saying, did you make sure that all the tick boxes have been checked because you have done things according to the law, not according to how you feel at the particular moment or because you want to accede to political pressure or anything else. Yeah. So what we are basically saying right now is the 178,000 people are regular. When you are saying they should move to work permits of a particular nature, when you know that you have got asylum seekers, a huge number of those people are asylum seekers where their decisions were not taken to the next stage to decide whether they are refugees. And all of a sudden, 13 years down the line, and somewhere here from 2000, you are saying you need to apply for a different permit. This is an asylum seeker who could have qualified for permanent residence or citizenship. But now, where are you saying this person must go? Go and start the asylum seeker process from scratch, or do what? Because the person already has spent.
Again, I wish they would be here so that they raise these issues. But they've raised these issues with us in previous conversation. And they're saying, Dr. Sibanda, who's to say that 178,000 people are going to be declined?
Now, the waivers that we're talking about, that people are being asked. Remember when these permits were issued in the first place in 2009, these people did not qualify, for ordinary, permits, the general work permit or any other permit. That's why they were given these permits. So to come today and then say they are going to qualify for general work permits, and by the way, South Africa has moved almost away completely from the general work permit, to the extent that now what exists is the critical skills permit. And the critical skills permit, the current minister has even scrapped the waiver that was there that would say if you have a critical skills permit, you will qualify for a PR. Now, you must also have a permanent job that you have been offered in order for you to get, PR as a critical skills permit holder. So what we are saying now is you ordinarily know that the conditions that existed, that these people did not qualify for this particular permit. And now you are saying, go and, apply, for that permit and ask for a waiver. And you are saying the waiver that they should be asking for is that, South Africa must now apply, give them a job which any other person can take. When at the current moment, even the immigration policy that is coming in is trying to minimize the number of people that are taken in on general work permits. So this is just impossible. Yeah. It's asking for what's not going to happen.
Gary, does one, are those rights automatic? But two, the minister says we've got numerous permits. It's not only the general work permit that you can apply for. There's relative permit, there is study permit, there is critical skills permit, which you've already mentioned. There's a number of them, and who's to say that in one or other dispensation you might not be accepted? He says, for example, in the whole globe, when it comes to study visas, in the last financial year, Jan 2021, December 2021, 14,000 study visas were approved. 25% of those were Zimbabweans. 28% in the same period, critical skills visas were Zimbabwean. 15% general work visas in that particular period were Zimbabwean. So saying there is no such a thing that everybody is going to be rejected in this reapplication process?
I mean, the truth is that just from our own practice and from our own observations, and I've checked this with other immigration practitioners, a very small minority of the 178,000 ZEP holders qualify for mainstream visas. Those that did qualify applied for them. That's why so many applied for them in the past. But I'm afraid in this last 6 months, since the ZEPs were stopped, very few of these individuals have applied for mainstream visas. And I want to add this, we have a constitutional concept. Let's back away from the technicalities of Paja and the Constitution. Ubuntu, it's a philosophical concept. It's also a constitutional concept of reconciliation. What would it cost the Minister of Home Affairs to hold a public inquiry? It wouldn't cost very much. It would be the right thing to do. That's what Ubuntu is all about. That's what our constitutional court has cried out in situations like this, where you have a human rights crisis on our hands, and this could be alleviated. What would it cost the Department of Home Affairs and the Minister to lead a public inquiry, and why is this not being done? I just don't understand it.
Let's listen to some of your views then tonight. 072-110-554. You send us this WhatsApp on the conversation tonight. Mutobi in Ormond. Does South Africa have enough resources to cater for all Zimbabweans or all Africans who want to live in South Africa? We'll canvass that question with our panel when we continue. Let's remind you of that poll question once again. Should Home Affairs be criticized for its withdrawal of the Zimbabwean Exemption Permits? Please reply yes or no to that question at Newzroom 405, or send us your views tonight on WhatsApp 072-110-5584. In Focus continues shortly. Back with you tonight here on In Focus, Newzroom Afrika, channel 405. Conversation continues. I must apologize. We had Tonic on the line. He did indicate to us that he's having challenges with load shedding. We seem to have lost him. And Tonic, if you can, please do establish that connection with us again, because we are trying to reach out to him at this particular point. There's some difficulty in that connection. We'll try and get him on. But we still have with us Dr. Vusumuzi Sibanda. We've got Gary Eisenberg, as well as Lindokuhle Mdabe still on tonight. Lindokuhle, let me come to you then on this question of waivers, right? So it's been said over and over again that people have got roots now here, others got married, others have got children. And I look at that and I'm saying, I'm sure if that is the case that you make to Home Affairs as a waiver, that would stand. And why should that not stand?
Yeah, so those are important considerations. People's lives are settled here, and one would expect, and I suppose, as already Gary has said, that a humanitarian response is going to come from a minister. The reason why that is not part of the consideration is because the process itself is flawed, and I don't know how many times we have to emphasize this. And had there been a process that is open, transparent, allowing for people to voice the kind of impact that they're going to suffer as a result of this decision, one would have expected that such impact would have been something that is put forward by people who are affected by this decision. We are unable to comment on any of these things because that is not really what should be part of, or which should be part of the discourse, but it's not part of what is now an official complaint against the decision of the minister. The complaint is a narrow conversation. It is saying to the minister, in a democratic state, what you ought to have done is to allow people to voice to put in the frustration with the decision that you would have taken as a minister. And the minister ought to have allowed that. He hasn't allowed that. He's anticipating a withdrawal this case. It's unlikely to happen. This is an important case. It's important for more than just this issue. It's important for other cases.
Yeah. So, Lindokuhle, while we are there, so Paja says a fair administrative procedure depends on the circumstances of each case, right? So whether or not it will just be a notice or whether there will be a public inquiry, it depends on the merits of each case. So what is unique about this case that would say, let us have or hold a public inquiry or not follow the other process of just issuing a notice?
Yeah, that is important. I think that is an important gaze at the issue, and it'll be very interesting for the court to decide that question. But this is what I think is the law, over and above what you've just said right now. It is that when there is no procedural mechanism within which you can facilitate the hearing of the other side in terms of a specific legislation that you're dealing with, then you can rely on PAJA. We know that in the Immigration Act, there isn't any specific procedure within which the minister can facilitate a wide range process where people are heard, where a majority of people are heard and are given some sort of a determination after a meaningful participatory process. So in the absence of any mechanism in the Immigration Act, what you are then left with is PAJA. And then PAJA gives you some sort of mechanism to work with. But it doesn't limit you to that mechanism. One would expect from a minister who comes from a human rights tradition and social justice tradition to be inclined to expand the measure of rights afforded to South Africans. He comes from an organization of giants. He comes from an organization of well-meaning people. One would expect that he would follow from his ancestors and perhaps take leave from that and begin to expand the rights of people in a meaningful way. The fact that he is not gazing in that direction is worrying for the moral authority of politics in this country.
So Lindo, there are some who argue in that regard in the doors of government, and I've seen this argument going back and forth on Twitter, the argument on Ubuntu and compassion and so on and so forth. Some are arguing that, well, the 12 months grace period in itself is an act of Ubuntu.
Yes, one can only expect to come to that period after you've had people, right? 12 months period, and then you say to people, well, that is within that period, you then have to explore other options that are available to you. We all know, and he knows this, he must know this, that there are only two available options, real options. And other permits, Gary was right on this score. Other people who wanted other permits would have already applied for them. The only gateway, the only path here for people to find some refuge and asylum in this country is through the asylum seeker refugee permit. And this is the real option. The fact that this decision is taken, it can only mean that we are very well saying to Zimbabwean migrants that, well, the special dispensation has come to an end. It's time for you to go. And this I think is the only real conclusion here. We can only the only thing that is now that is able to save us and Zimbabweans
Right.
It's the court.
All right.
We've tried all means to negotiate to write to the minister. We haven't had any response from him.
Well, let me tell you this, Lindo. I mean, I did suspect this would happen. We did reach out to the minister and his office, and at the time of coming on air, we had not received a response for them to come on. But they have been watching, and so the minister is now joining us on the line. I'm sure he's listened to some of the things that you have put on. Minister, good evening, and thank you very much for your time. Dr. Aaron Motsoaledi, Minister of Home Affairs, joining us on the line. First and foremost, Minister, we're reading some statements online, and maybe you are also meeting these statements online, was that two of the organizations that were taking you to court have withdrawn. We're hearing here today that that's not the case. Maybe start by responding to that.
Well, we have responded. Good evening, Thabo, and good evening to the listeners and viewers out there. I'm watching TV. I'm not home. My phone is dead. I have to ask for somebody's phone because I was not aware that I was supposed to be part of this discussion and that I was supposed to be in the studio. I will have been, Thabo, because I don't want the public to be misled also in my name. The story about whether it's true or not, whether people have withdrawn, we have submitted to the news houses which have asked that question. It was Rabol and News 24. We have submitted our documentation and proof about what we believe, and I don't think it's a worthwhile debate to say we are correct or not, but we have submitted documentation in the manner in which we understand it. Remember, we have got our own lawyers. They are the ones who responded to us, who told us this. We are not just guessing. So let's leave the law to take its course and tell us whether we're right or wrong on that one.
All right. The second question that is a question of holding a public inquiry before taking a decision to not extend the life of the ZEPs. Did you consider that, and why didn't you? If you didn't.
Why was there no public inquiry when these permits were issued? There was no public inquiry. What we did, as far as I understand, Paja, is that the people who are affected, because we have got their phone, their files, the 178,000 of them, we wrote them letters according to the emails that were in the files. We then thought maybe that might not reach them for one reason or the other. We sent them SMSs. Then we thought that might not be enough. We bought space, advertorials in newspapers and advertised. We also then put it on our website. Then there are a few NGOs who inquired about this and asked for meeting with us. I'm hearing there that we never did that. There are quite a number of NGOs, some of them saying they represent the Zimbabwean permit holders directly. We have quite a number of meetings with them. Some of them, we even responded to them in writing before such meetings. So we believe that is adequate. If it's not adequate, it's not because we were deliberately snapping somebody. We thought that is the right process we have done as far as Paja is concerned. And our interests are directly the people who are affected.
Minister, can I ask you to stay on, because I know you want to respond to these things. So I need to take a break, unfortunately. But I'm going to come back to you, Minister, and raise some of those issues that have been raised here tonight. Minister in Home Affairs, of course, he has called us because he's watching the show. We did reach out to his office at earlier point. We didn't get a response in time before coming on air for this conversation.